Have you been told by credit repair experts and sometimes in books that after you do 1 or 2 rounds, especially if you are doing your 4th round, they usually suggest this at the 4th round, you need to send a letter threatening the creditors or the credit bureau, allowing them to know that you are going to sue them if they don't delete this information. And you are told usually the credit bureaus is going to tremble and delete all the information. And then when you do it in real life, you realize that they don't respond or pay you in the mind. They just respond and say, we have updated the information in your file, or we have modified your file, or we have verified this account, or the reporting has conformed with the FCRA and its requirement, and we are accurately reporting this account. And you're saying, what? I just sent a letter of threat. Why is it that they didn't tremble as the book or the expert tell me they would do? Why does this happen? It's not every threat that you send in your letter has any standing in court or the credit bureaus will be shaken by. You have to have the right language and you have to know how to prove what you are saying that they are liable. It's not every violation of the FCRA and other laws you have a private right of action. That's a legal term, which means you, the consumer, can bring a case against the furnisher or the credit bureau in a court of law. I am going to tell you when this is possible and tell you how to use it so that you are able to get results and so that you are able to trust and then know that you have a real case. Welcome back to Credit Nerdy, brought to you by Ironic Financial and Ironic Credit Products. Ironic Financial, where we help you to repair your credit and restore your credit and structure your credit the right way so that you are in a better position to make better moves with your credit. Your credit needs to be structured the right way. It's not just to clean up negative items, but to make sure that information that is in there is the right information and the right amount of information that will give you a favorable outcome. And we do that at Ironic Financial. If you want to do it yourself and you want products to remove charge-off, identity theft, collections account, late payment, inquiries, accounts that was previously deleted and is reinserted back to your account, you go to Ironic Credit Products and you will find these booklets. They don't just give you letters that is grounded in consumer law and case law. They also gives you how specific aspect of your credit report work and what you should pay attention to when you are disputing particular kinds of negative information. The approach that you would use to dispute a charge-off that is not in collections is different from the approach that you will use when it's in collections. And we make sure we point out those things to you in your products. That is the value of our products. We are not just selling you letters that is constructed. And the amount of letters that we give you in our products, I am not aware of anybody else on the market that is actually giving you this much letter. Our product has roughly about 20 documents that you should use. Some of them are affidavit and the rest are letters. Alright, let us back to what we are here to discuss. Why is it that when you threaten the creditors, especially, let me deal with the creditors in this video. Why is it that when you threaten the creditors do not actually do what you tell them? Because under the FCRA, there's only 2 ways you can get the creditor in court. So if the creditor, and this is going to shock you, if the creditor is reporting inaccurate information, listen to this, and listen how crazy this is. If the creditor is reporting inaccurate information on your credit report, you cannot just sue the creditor or the furnisher for inaccurate reporting. Can't just sue them. You won't be able to bring a case. Under the section that deals with reporting inaccuracy, it's only state agencies and federal agencies can sue the furnisher or the creditor for inaccurate reporting on your credit report. No one has told you that, right? A matter of fact, lawyers tell you, but most of your favorite credit repair experts don't tell you that. So when you write a letter to the creditor, data furnisher, and says to them, I am going to sue you because you are violating my right under the FCRA to a fair and accurate credit reporting, they're not going to budge because they know that you can't sue them. It's only the government have the right to sue them for that. You can sue them for that, but you have to do it another way. There's 3 ways that you can do. You can use other state laws to rest the FCRA violation under, and then you sue them. I am going to cover this law in another video when I deal with your right to privacy, because I have this law and I don't really hear anyone talking about the power of this law, both federal and state law that exists that can help you to really bring the ease to the creditors and the credit bureaus. So you can't just sue them outright just to say they are furnishing inaccurate information. You can't just sue them. You will not be able to bring a case because that specific section of the FCRA is only enforceable by state agency and federal agency. There's no private right of action under that. How you can sue them for inaccuracy is this. This is where liability lies, where you can sue them if they are inaccurately reported. You have to point out to them that there is inaccuracy. And if there is a legitimate case of inaccuracy, you have to prove that they did not employ reasonable procedures to do a reasonable investigation. Once you can prove that no investigation was done, that would have reasonably showed the inaccuracy to be true, that's where you get them. That's where you have a private right of action. So just on the grounds of let me run it back by you so it's clear, because it might sound confusing. Just on the grounds of the inaccurate reporting, you cannot sue them. And you cannot bring a case. We don't have a private right of action under the law in respect to that particular issue. It's only the federal government, federal agencies, and state agencies that can bring a case just by the sake of inaccurate reporting. All we can buttress the inaccurate reporting and bring a case is that initiate an investigation to dispute the inaccuracy, and once they did not correct it and it can be proven that it was inaccurate and you can prove that they did not do a reasonable investigation and that's why it remains, that's where you have a private right of action. So when you are crafting your letters about attacking the creditors in terms of inaccurate reporting, you have to have the language of unreasonable investigation and proper procedures and reasonable procedures to do a reasonable investigation. And once you can prove that if they had done a certain level amount of investigation, the inaccuracy would have been discovered, that's where you have your grounds to threaten them. So when you craft that letter, that famous threat letter of legal action, you got to have the language of the lack of a reasonable investigation in it. That's where the liability is triggered under the FCRA. Another way, the best way, once you realize that inaccuracy is here, Because you would hear individuals, and I know why they say this, and in some cases it's the best. And when I say individuals, I am not down talking anyone. Anytime you hear me make my videos, and I say other individuals, I am not down talking anyone. We're not in a competition. All of us are out here, those who are doing this fairly and the right way, and is spending the time to study, spending the time to present accurate information, and is not just looking for a quick dollar to please individuals. I am all for us teaching the public, because most people in the public do not know their rights and do not have information. If we are willing to dedicate ourselves to help, we are not in competition. We are here just to help the community at large. And when I say community, I'm talking about consumers. All right? So, when I say others, I am not poo-pooing anyone or attacking anyone. We don't operate like that. Every one of us is out here doing our thing. Some have more information than others. Some have better sources of information than others. And everyone is trying. So I am just here to help. And those who are presenting information, they can learn from my videos as well. So when individuals now usually tell you, it's best to just dispute with, go directly to the furnisher, because they are the ones presenting information. Why? Sometimes that's not the best route. So for example, if you are actually disputing inaccuracies and you want to have a case where you can send threat, or where you will have a case that is threatened by the reasonable investigation aspect, do your dispute through the credit bureaus. Why? Let me give you a subtle nuance here, and I think I covered this in my video that deals with frivolous. If they respond to you that your dispute is frivolous, if you submit a dispute to the creditor or the data furnisher directly, they can respond to you if you have not stated clearly your case of what you are disputing. They can reject your dispute as being frivolous. And as a result of rejecting your dispute as being frivolous, they don't do anything. But once they do that, they must tell you exactly why they deem it frivolous and what information or what you would need to do for them to take the dispute seriously and do an investigation. They must tell you that. Here, the game changer now. If you do the dispute to the furnisher from the credit bureau, once the credit bureau did not tell you that the dispute is frivolous, and if the credit bureau does that, they have to follow the same procedure of telling you why they deem it frivolous and what information you need to supply for them to do it. They can't just reject it as being frivolous. They need to tell you why they came to that conclusion. Alright? If the credit bureau, you do the dispute to the credit bureau, once they did not, listen me carefully here, once they did not mark it as frivolous and they forward it to the data furnisher or the creditor cannot say that the dispute is frivolous. They have to conduct the investigation. Let me run that back so it's clear to you. If you dispute it directly with the creditor can mark it as frivolous, but they must tell you why. But if you go to the credit bureau and the credit bureau never mark it as frivolous before they send it to the data furnisher cannot then mark it as frivolous. They have to investigate it. If they do that, they then become liable under the law, and you can now sue them for not conducting a reasonable investigation. So why it is important under this, if you want to bring a case, that you do it through the bureau. Once you do it through the bureau, most of the time, the bureau will forward the information to the creditor, and the creditor cannot mark it as frivolous, and as such, it would have fulfilled the requirement of the creditor having knowledge that the accuracy is disputed, because in section 623, responsibilities of furnishers, it says once the furnisher have knowledge that a dispute is made concerning the inaccuracy of the information, the creditor or the furnisher must not supply that information to the credit bureaus anymore. It must be deleted. And if the section defines what it means in terms of what it means when they know it was brought to their attention and they have knowledge of it. So once that is done, that again now build your case where you initiate an investigation. And if they come back and tell you that, you know what, we see this as being accurate, and you can prove that it's not accurate, it means that a reasonable investigation was not done, and that's how they are now liable under the law. So there are certain aspects of the FCRA, if it is violated, we don't have a case because there is no private right of action, and the furnishers are protected a lot. This is the only area you can really tie up the furniture, but you have to find a way to show that if they had done proper investigation, they would have detected the error that you are pointing out. So the liability and a private right of action will be triggered in terms of the creditor or the data furnisher when you can prove that they did not conduct a reasonable investigation. Alright? So it's not just on the ground that this information is inaccurate and I'm going to sue you because it's inaccurate. No, you have to have language of reasonable investigation not being done and be able to prove that what they did was not reasonable. And that's when you get them. So don't just write a letter saying, I am going to sue you. They know where liability lies under the law. So when they see a letter like that come through, they are not going to pay it no mind because they know it's empty threat. They know that it's empty threat. And we also can carry liability under to the creditors once we can prove that the creditor, credit bureaus, the credit bureaus, we can actually prove that they did not conduct a reasonable investigation too, and they did not use reasonable procedure to make sure maximum possible accuracy in their reporting. And these are the ways that you can do. So you have to understand when to use that language in your dispute letters for it to have an effect. Now, I said to you about court cases, right? But here the other way. Let me give you this one. I'm going to give you this as bonus. Here is the other legal way that you can lick the furniture now and get them to take off things, even if you can't carry them to court. If there is a dispute over inaccuracy and your agreement with them, the credit agreement has an arbitration clause in it, any dispute that surrounds that account, you can actually go to arbitration. So that is another legal way that you can get to them. So once you want something to get off, even if you don't have any grounds to take them to court, once there's an arbitration clause, you can use that arbitration clause. And in most cases, most agreements will put the burden to pay for arbitration, except like a filing fee. Most of it will be on the back of the creditor, whoever constructed that agreement. Most times that's the language that's there, and that's just industry practice. So make sure you pay attention to that. And once you realize that they will be paying for it, a lot of times this costs thousands of dollars, and they're not going to go down the road to pay that. So they might be more willing to delete all the information. So once there's inaccurate reporting and a dispute and they're playing ardent, if you don't have an argument where you can really move and prove that with certainty and clarity that a reasonable investigation was not done, then arbitration is your best bet, and they're going to run from the arbitration because sometimes the arbitration, not in all cases, sometimes it's more expensive than the litigation, and they don't want that, and they have to put up thousands of dollars up front in order to do the arbitration. So that's where you get them when you have something that you gotta deal with. Alright, I hope that this was helpful, and I hope that we construct better letters and use that language properly and in the appropriate place and time and in the appropriate scenarios. Not every violation under the FCRA we have a private right of action. All right, it's your boy Genius coming to you again. Peace.